Good morning, everyone. I want to apologize up front for any ramblings that I do today. I made the poor decision of staying up too late last night watching the Knicks lose. So, any Knicks fans out there, I'm with you. Okay, so with that said, um, if you take away anything from this presentation today, a couple of things, because it's a long presentation. I give some detail on the background of both trademarks and copyrights, but here are the nuggets that I'd like you to take with you. Number one is intellectual property provides the right to exclude others from doing something. That's number one. Number two, if your school doesn't have an IP policy, you should consider getting one, and we can certainly help you with that. And number three is start with the assumption that you need permission to use copyrighted works. So those are the three things that I'd like you to take away. All right. On to trademarks and copyrights. So trademarks and copyrights are part of four main categories of intellectual property, as you see here. Also includes patents and trade secrets, which we won't touch on today, but maybe in a future presentation. So the importance of IP protection. Well, first, it's a grant from the government for individuals' creations, and it's used to protect innovations and R&D investment, product differentiation and brand equity and market share. You can also create barriers to competitors. There's that right to exclude again. Create and maintain value for goods and services, attract investment dollars, and generate income through commercialization of either your goods and services. First up, trademarks. Well, what is a trademark? Well, it can be a word, name, symbol, or device or combination thereof. And you'll see I have a couple examples over here. Starbucks coffee and Baldwinsville bees. And use of that word needs to be in conjunction with particular goods or services. So, of course, Starbucks with coffee, Baldwinsville bees with educational services and athletic services, for example. And there are some non-traditional trademark examples here, can be color and sounds. There are two types of trademark protections. One is common law and one is a federal registration. First, common law. First one to use a trademark in conjunction with a particular good or service wins. And that trademark right is created when you start using the mark in commerce in conjunction with particular goods or services, and the consumer begins to associate that mark with your goods and services. And it's based on the first use of that mark in commerce with those goods and services in a particular geographic location. That's one limitation that the federal registration doesn't have. And the term of a trademark, well, as long as the trademark is in use, unlimited life. On to federal registration. There are a couple of different types of applications you can file with the United States Patent and Trademark Office. Number one is a use-based application, and the second type is an intent-to-use application. Basically self-explanatory. If you're using a trademark in commerce in conjunction with a particular good or service, you can file based on that use. But if you file an intent to use, you need to have a bona fide intention to use that mark in conjunction with the services or goods you file with. And even though you might receive a notice of allowance on that trademark application, it won't register until you show proof of use. And the term of a federal trademark registration is unlimited. However, we're dealing with the government here, so you have to renew and pay a fee every 10 years. So here we are at one of my main points again. With common law and federal registration, it allows the trademark owner to prevent others from using a confusingly similar mark on comparable goods or services. Now, typically that's done with first sending a letter to a potential infringer and demanding that they stop using the mark. And if that doesn't work, your next step is usually filing a lawsuit. And I have, you see the money signs there, but another remedy, and the usual remedy is either sometimes it's money with trademarks, but most of the time it's an injunction to stop or prevent the alleged infringer from using the mark any longer. So rules of thumb with respect to whether you should register a mark or not, and certainly you don't have to follow these, but this is some of the advice we usually give. So it may not be worth registering if you use the mark only for a short period of time, less than 2 years, because the process can be expensive and it can take some time. What might be worth registering is if you're trying to develop a brand name recognition and a mark, on one of your products you think is going to sell really well, or one of your main services, or even a house mark, the name of your company, for example, or school. And if you're planning on expanding the geographic coverage. So here we are to the big page of what a federal registration can get you over common law trademark protection. And you see there's a lot here, perfection rights across the United States. And as I said in the beginning, with common law trademark rights, they're geographically limited. With federal, they're not. Provides you with federal court jurisdiction. You can sue in federal court. It provides a presumption of ownership, validity, exclusive rights in the mark, and continuous use. Provides constructive notice to potential infringers. There's certain statutory remedies available, such as treble damages. You can bar infringing importations, and it becomes incontestable after 5 years. So a lot of benefits for filing. On to selecting a mark. Very important. And this is where we work with clients a lot. And 2 basic requirements. Number 1 is the mark must be distinctive. Must identify the source of goods and services and not be merely descriptive of those goods and services. And it also must not be confusingly similar with a mark that's already being used. So let's take a look at what number 1 means first. So this is the distinctive spectrum. You want to be on the left-hand side. Okay, you want to pick up or make up a fanciful name, such as Clorox for bleach. That's automatically distinctive. So is an arbitrary mark is going to be automatically distinctive. You're going to meet that first requirement. For example, use of Apple for computers. That's an arbitrary use of a mark in conjunction with an unrelated good or service. If you start getting into this descriptive portion of the spectrum, that's not going to be automatically protectable. For example, dry fast glue, you can see that it describes a characteristic of the product. So it's going to take some time. You're going to have to sell that product to consumers, and they're going to have to start to associate that mark with a source. So obviously the primary meaning of this word is a characteristic of the good. Secondary meaning would be the consumers, again, identifying this mark with a source. Take some time. We're always trying to push clients to be on this side. And there's certainly tension between these two because understandably clients want to advertise the benefits of their products, and they're often thinking of marks that are descriptive. But again, we try to push them towards this side because then you meet that first requirement, distinctiveness, and then you only have to meet the next one, which is, hey, let's hope that there isn't a mark out there that's confusingly similar. How do we figure that number 2 out? Well, we can perform a quick knockout search. We'll do searches for clients very quickly, or often we recommend having a third party do a search for us. And we'll send that mark out in conjunction with particular goods or services. They use an AI program to search various databases, and certainly it's more comprehensive, and we get a huge list of potential marks that we need to review and then go over the client. So the full search is certainly preferred, especially if it's going to be one of your primary marks. But again, we can do a quick search, and a search is not required. However, we highly recommend it because it can be expensive if you need to change your mark later on. Okay, proper use of a trademark should pass the acid test. No, certainly not this acid test, but this acid test. Okay, so it must be used as an adjective as number 1. So what does that mean? Okay, using trademark appropriately. You don't want to use it as a noun. You want to use it as an adjective, like I said. So, for example, buy Lego toy blocks, not buy Legos. Similar with Band-Aid, and buy Nike sneakers, not buy Nikes. Don't want to use it as a noun. And beware of genericide. So if you start using it as a noun, it's not being used properly anymore. And that's what happened to these marks. They used to be registered, uh, and they've been genericized. Is that the hopefully that's the right word, but they're no longer a valid federally registered trademark. And as you can see, some companies want to prevent that. And for those of you of a certain age, I'm sure certainly remember saying, can you Xerox this for me? And Xerox wanted to prevent. Um, it's very strong trademark from genericide. So you can see these advertisements that they put out. There's no such thing as a Xerox. Okay, C, consistent and continuous. The mark should be used the same way each time. And you can see this is a Baldwinsville B, and um, they the school uses the B like this every time. In other words, it doesn't have different wings, different shapes of wings, different positioning of the wings, or different positioning of the B. It looks just like this every time. Identification. So it's highly recommended. Let's say you don't have a federal registration, you can still use TM for marks used on goods or SM used for service marks to indicate that the mark is being used as a trademark. The circle R symbol can only be used with federally registered trademarks. And again, it's used to alert the public that you have a federal registration on a mark and not to copy that mark. D, part of acid. Distinctive, we've already talked about this a little bit before, but also the mark should be distinguished from other words in text if you're not using it, like in the upper left-hand corner of your website, for example. If you're using it, a word in text, it should be highlighted and distinguished, at least with a first capital letter or with quotation marks. You can see here, or all caps, distinctive print, distinctive color, etc. This use emphasizes that the term is being used as a trademark. Okay, so proper use of a trademark for goods, the mark needs to be used on the product or the product packaging, preferably. Can include a product label. It can be also used on a website if you're selling goods. But if it's used on a website, there also has to be a means for ordering the goods. So if the mark's just used on the website, you're selling coffee mugs, for example, um, there has to be preferably a button to buy, like a buy now button is preferable. For services, it's easier to show proper use, and it can be used on a website or other marketing material that describes the services. So the mark plus description of the services will be a proper specimen. And I have some examples here. Unfortunately, I don't think I can get with the way I'm presenting, but I think this one is, I went to this school in my earlier days, so I just picked this one for the Baldwinsville Bees. But they use consistently their B mark in the upper left-hand corner, and it's actually very similar to Target, which I use as an example. They use the Target symbol upper left-hand corner. No matter where you go on the website, the trademark's always used, and it's a great use of a mark if you want to check those two out. All right, I mentioned this a little bit before, but the trademarks clearance search is the knockout and the full search that I talked about. This is just to remind you that, if you're working with an attorney, you should pick several marks because oftentimes the marks that you pick are going to be used by others in conjunction with the same services or goods. So it's good to pick 3 or 4 that you'd be comfortable with, and then we do a search on those. And what I note down here, I mentioned before, is if you start using a mark and you find out later that somebody else has rights in the same or similar mark, it can cost a lot of money to rebrand, and it may cost money as well uh, to stop based on a demand and a cease and desist letter from a potential competitor. All right, so that was a speed run through trademarks. Since I'm not in front of everybody, I guess I won't ask for questions, but I'll go right into copyrights now. So what is a copyright? Well, copyrights are governed by federal law exclusively, and it's original work of authorship that's fixed in a tangible medium. I'll break that down for you here on the slide. So original has to be new to the author. Tangible medium can be paper or electronic. So words fixed to a page, voices fixed to electronic media, images the same or videos, and software fixed to computer memory. Copyrightable subject matter. Here's a long list of what can be copyrightable: literary works, musical works, dramatic works, recorded music, videos, photographs, computer programming. Some more examples within those basic categories. Company's website, the selection and arrangement of the layout, the designs used, the photographs used, product manuals and brochures, articles, class syllabus, course materials, lecture outlines, tests, notes, presentations, training materials, and so on. Importantly, what does copyright not cover? Doesn't cover inventions, procedures, or discoveries. That's more the patentable land protection landscape. Business or product names, that's more trademarks. Same with short phrases, potentially. Works by the US government, not protected by copyright. Works not in a tangible form. I say speeches here, but I mean someone giving a speech without notes, not being recorded. That's not in a tangible, fixed in a tangible medium. Works in the public domain, and ideas and facts. This is probably the most important part right here. Copyrights don't protect ideas or facts, only the author's particular way of expressing an idea or information. So protection is automatic for copyright. It begins with creation. So as soon as you take those notes, as soon as I prepare this presentation, protection is fixed. Registration, however, federal registration is a prerequisite to filing a lawsuit and can be important when seeking statutory damages. And that's highly recommended in a number of cases because, excuse me, it's difficult to prove actual damages sometimes. If a competitor or someone else steals your work, makes copies, distributes the same, it may be difficult to determine what you lost based on that stealing from you. So if you register within 3 months of first publication of the work, you can seek statutory damages between $750 and $30,000, depending on how willful the infringement was. And if you can prove willful, it could go up to $150,000. That's per work. And you can also seek attorney's fees. So it can be very important to register within 3 months, again, of first publication. Copyright, the lifespan is not as great as trademarks, but it can be, somewhat limited. Life of the author plus 70 years or 95 years from publication if it's a work made for hire. We'll talk about what those mean. Copyright owners' exclusive rights include, obviously, copying, the preparation of derivative works, the distribution of the copies, public performance, and public display. And a copyright owner, here we go again, can exclude others. This is their right. They can exclude others from engaging in those actions regarding their work. And they can seek redress, including, as I mentioned, statutory damages or an injunction from further copying or distribution, for example. All right, ownership. So the author or an individual or co-authors are the creator of the original work of expression fixed in a tangible medium. So that author in the first instance can be the owner. Work for hire, the employer in the first instance is the owner. And that is a work made by an employee in the ordinary scope of his or her job. So this presentation, for example, that I authored, I certainly took some from some of my colleagues, but I authored a lot of it, is owned by Bond, Schoeneck King, not by me, because this was made in the ordinary scope of my job. And third way ownership can be made, I guess, is through contract. So the first author could assign that work to somebody else. If they're an independent contractor, for example, making a work for someone, and then they assign that work to another individual who could then register that work. Copyright notice. Well, that notice is no longer, it used to be required, but it's no longer required. But innocent infringer defense, what does that mean? Well, if someone uses, meaning reproduces a copyrighted work or distributes the same without permission, and there is an owner out there, but there's no way of really knowing that it's protected by copyright, they may make an innocent infringer defense, which means that even if they're found liable for copyright infringement, their damages are limited. I think it's like $200 or $250 per within the copyright statute. So three elements, and this is recommended. It's an easy lift. You have to either say copyright or COPR or the C with the circle symbol, year it's first published, and name of the owner, as I show by an example here, and then all rights reserved. Fair use, everybody's favorite topic. A comparative advertisement can be fair use. Educational use, scholarly use, or a parody may also be considered fair use. However, the determination of the existence of fair use defense is not easy nor straightforward. There are no bright line rules. And the determination involves weighing certain non-exclusive factors. There are a lot of fair use checklists out there that can assist with the process. The checklist I have here from Columbia University is a good one. They have checklists on one side, whether it can be fair use versus checklists on another side. But certainly when you're checking left or right, educational use, newsworthy, just contains facts, those types of things on the left, non-commercial, they can all be checked, but still you're going to have to speak to an attorney to determine whether there's really fair use involved here. Again, it can look very good based on the checklist, but that's really the first step. You still have to determine whether your use is going to be fair. Like I say here, it often remains elusive even after the factors are weighted. So another one of my notes up at the beginning of the presentation, permission to use copyrighted work almost always is required. At least you should start with that presumption. And providing credit to the source of the copyrighted material is not a defense to copyright infringement. So some practical considerations. What's the risk? Do the checklist. Follow an IP policy if you have one. That's legally. Practically, what's the risk? And certainly this is a business decision. How likely is the copyright owner, for example, to find out what you're doing? Are you doing this in a classroom that's closed and not open to anyone else? Or are you publicizing this globally? Some things to certainly to consider. And statutory damages, like I mentioned, injunction, bad press if it's found out. There is a classroom exception, which states that the public display or performance of copyrighted works in face-to-face teaching is generally allowed. That's per statute. certainly some further limitations to that, but that's a big deal for the classroom. And the library has some exceptions too, which I won't go in. I could do a whole presentation on that, but just note that it does. And we can talk about that offline if you have questions. All right, down to some practical implications in the halls of learning. So one thing that I didn't mention, but I think it's related, so I should, is New York civil rights law. Everyone has state law covers the rights of privacy or publicity, and that relates to using their name or likeness or pictures for commercial gain. And certainly on school pamphlets or marketing materials, students may be used, and you need to get the permission of students and or their parents in order to put them in any marketing materials or the website. Off over to the right here, software licenses can be important in the copyright realm. You may have a software license with certain seats that you have, and we get calls a lot from educational institutions that and other clients that may have let others use those seats or duplicated those seats, and that can become a problem with software owners, and they often can tell when you make either copies of the software licenses or let others use them, and that's a copyright issue and a contract issue, and that can certainly lead to high damages and maybe canceling of your license. Website postings is another one we get a lot of calls about. Teachers or professors or other administration grabbing a picture off the web and putting it up on their Facebook page, their school Facebook page, or their other page that's associated with them in the school. And believe it or not, copyright owners in photos or other designs that are on the web have attorneys that scrub the web, and they will find that, and you could possibly get a letter. Again, we get those calls all the time, and typically the client will end up paying low thousands of dollars, between $2,000 and $4,000 for that infringement. IP policies I mentioned at the beginning. It's very good for a school to have an IP policy. What's in the IP policy? Generally, 40,000-foot view is ownership of intellectual property. Does the professor or teacher own what they create? What rights do they have with respect to copyrighted material? Are they allowed to make copies of portions of work versus the whole work? What do students have to pay for? What are students entitled to with respect to their creations? That sort of thing. So a lot goes into the IP policy, and it just gives great information to everyone involved in the school, the employees, the students, with respect to their rights and obligations regarding their own intellectual property and intellectual property of others. And online course materials, certainly, like I mentioned before, course materials of the professor can be copyrightable, and they can either be owned by the professors or the school, depending on the relationship the school has with the professors and contracts involved. Here we're just showing, here's trademark protection with respect to a school. The mascot, for example. Also, with stadium and theater music licenses, playing music at the stadium or in the theater, you need to obtain what's called a mechanical license, typically to play that music or that score. That's a public performance. That's one of the bundle of rights of a copyright owner. Booster club licenses, they may sell T-shirts with the school logo. You want to have a contract with those booster clubs and what they can and can't do with the school logo and name, and where they can sell it for how long. So that can become very important with those license agreements. And very similar with third-party licenses, schools will contract with online and brick and mortar stores to sell their branded merchandise. And again, it's going to be a similar type of license. You want to maintain control, quality control of your trademarks. And to do that, you do it through a license. And I think that is it. So half hour instead of 45 minutes. Perhaps I burned through too quickly, but I appreciate the opportunity from the group to be able to present to you guys today. And certainly let me know if you have any questions. If it's something I can't answer now, I'll certainly consider doing it by email. Thank you.